Hello viewers, Namaskar. I am Professor Vageshwari Deswal, a professor at Faculty of Law, University of Delhi. We are doing a series on the new criminal laws. Today, we will be dealing with the changes that have been brought about in the new law in crimes of kidnapping, abduction, slavery and forced labor. So, first of all, we will talk about kidnapping. Section 137 of the Bharatiya Nyaya Sanhita deals with the crime of kidnapping. It says, kidnapping is of two kinds, kidnapping from India and kidnapping from lawful guardianship. So, it says, subsection A, clause A of subsection 1, whoever conveys any person beyond the limits of India without the consent of that person or of some person legally authorized to consent on behalf of that person is said to kidnap that person from India. And subsection 2, it deals with kidnapping from lawful guardianship. It says, whoever takes or entices any child or any person of unsound mind out of the keeping of the lawful guardian of such child or person of unsound mind without the consent of such guardian is said to kidnap such child or person from lawful guardianship. See, earlier IPC had covered these two parts in two different sections. Now, in one single section, subsection 1, A and B, we have dealt with what amounts to kidnapping from India and what amounts to kidnapping from lawful guardianship. And the main change is that we have replaced the term minor with the term child. Earlier, it defined minor as a girl who was below 18 years of age or a boy who was below 16 years of age. It was considered that maybe girls, they needed more protection till 18 years of age, but a boy was capable of taking care of himself once he attained 16 years of age. But now, we have the Juvenile Justice Act, we have the POCSO, wherein we have one uniform definition of child, and a child is any person who is below the age of 18 years. This definition has been introduced in the BNS also, and now it could be a boy, a girl, it could be a trans child. So, it has to be now any child or any person of unsound mind out of the keeping of lawful guardian of such child or person of unsound mind. When we talk about persons of unsound mind, so there is no age limit. They are always supposed to be in the care or custody of some guardian, and when we talk about children, so they are supposed to be in the care and custody of a guardian till the age of 18 years, because till that time they are considered as immature and not capable of taking correct decisions as to what is good for them. So, that is why there is this concept of guardianship, and here this is a crime against lawful guardianship. Although the one who is subjected to the crime is a child, it is a child who is removed from the custody of the lawful guardianship, but the rights of whose rights have been violated here? The rights of the lawful guardian. So, you see, kidnapping is a strict liability crime. In abduction, the victim's consent can negate liability, but in cases of kidnapping, the victim's consent is of no consequence, because here the consent is required is of the lawful guardian. What does the law say? If a child below the age of 18 years or a person of unsound mind is removed from the custody of a lawful guardian, it does not say whether the child had consented to accompany the kidnapper or whether there was any other thing or what was the intent of the kidnapper. Now, these are all immaterial here. Kidnapping, it is a strict liability crime. irrespective of the consent of the person who is kidnapped, because that person is a minor or a person of unsound mind. So, here we are talking about a person who is incapable of giving consent. Similarly, intention of kidnapper is also of no consequence. A kidnapper might argue that he had all good intentions and he had no wrong intentions against the child, but if what you have done, if it constitutes removing a child out of the custody of the lawful guardian, then the offence of kidnapping would be constituted. Because kidnapping from lawful guardianship is an offence against the guardian, and that is the reason why subsequent takers are not kidnappers. See, kidnapping is constituted only when the child is taken out of the custody of the lawful guardian. Suppose somebody removes a child from the custody of the kidnapper. Now that would amount to abduction, because that subsequent taker has not removed the child from the custody of the lawful guardian. The kidnapper is not the guardian. That is why kidnapping is a crime against lawful guardianship and an offence against the guardian only. Subsequent takers, they are not kidnappers. Now let us talk about the essentials of the crime of kidnapping. Here the law uses two terms. First is taking. So what amounts to taking? Taking could be actually. That is when you've actually picked up the child and taken the child away. And taking could be constructive also. That is when you've constructed certain circumstances that the child has willingly accompanied you. So that also amounts to constructive taking. Then the second term that has been used in the statute is enticing. So that is when you arouse a person, when you arouse attraction in a person, when you arouse interest in a person, or when you lure a person. So that would amount to enticing. So when the child is removed either by taking or by enticing, it would amount to kidnapping. Explanation says the words lawful guardian in this clause include any person lawfully entrusted with the care or custody of such child or other person. Other person here would be person suffering from unsoundness of mind. So here it is talking about a person who is lawfully entrusted with the care or custody. But there are certain exceptions to this provision. It says the clause does not extend to the act of any person who in good faith believes himself to be the father of an illegitimate child, or who in good faith believes himself to be entitled to the lawful custody of such child, unless such act is committed for immoral or unlawful purpose. If the act is done for immoral or unlawful purpose, then such persons, they would also be held guilty. The law says whoever kidnaps any person from India or from lawful guardianship shall be punished with imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine. So all this is the same. The main difference is that the term minor, it has been replaced with the term child. Now coming to section 139 of the Bharatiya Nyaya Sanhita, that deals with kidnapping or maiming a child for purpose of begging. Here again the term child has been introduced. It says whoever kidnaps any child or not being the lawful guardian of such child obtains the custody of the child in order that such child may be employed or used for the purposes of begging, then shall be punishable with rigorous imprisonment for a term which shall not be less than 10 years, but which may extend to imprisonment for life and shall also be liable to fine. So the punishment, it has been substantially increased in this provision, along with replacing the term minor with the gender neutral term child. Then subsection 2, it says whoever maims any child. See, child has replaced the term minor because therein minor had been defined in terms of being a boy below 16 years or a girl below 18 years. Now it is a uniform age for all children, and it says, whoever maims any child in order that such child may be employed or used for the purposes of begging shall be punishable with imprisonment which shall not be less than 20 years. So, see how the imprisonment it has been raised because the crime that is being committed is extremely grave here. You know, a child being maimed, a child being blinded, any of the joints being severed just so that the child may just evoke some feelings of sympathy from those from whom he is begging. So, when you are subjecting a child and his entire life in future to these kind of heinous acts, the punishment that the law prescribes is not less than 20 years, but which may extend to life, which shall mean imprisonment for the remainder of that person's natural life and also with fine. Subsection 3, where any person not being the lawful guardian of a child employs or uses such child for the purpose of begging, it shall be presumed, unless the contrary is proved, that he kidnapped or otherwise obtained the custody of such child in order that such child might be employed or used for the purposes of begging. So, there will be a presumption in such cases, and it would be for the accused to rebut the presumption that, see, I had not obtained the custody of such child to be employed or used for the purposes of begging. Subsection 4 clarifies, in this section begging means soliciting or receiving alms in a public place, whether under the pretense of singing, dancing, fortune telling, performing tricks or selling articles or otherwise, or entering on any private premises for the purpose of soliciting or receiving alms. Exposing or exhibiting with the object of obtaining or extorting alms any sore, wound, injury, deformity or disease. Sometimes what happens, children, they are subjected to such wounds or injuries, and then it is not allowed to heal because the longer the injuries they stay green. So, what happens, till that time they would evoke more feelings of sympathy from those people from whom they would be begging for alms. So, when any person exposes or exhibits with the object of obtaining or extorting alms, and for that they expose any sore, wound, injury, deformity or disease, whether of himself or for any other person, and sometimes they do this against innocent animals also, then using such a child as an exhibit for the purpose of soliciting or receiving alms. So, all this is now punishable, and you have seen that there is a grave punishment that has been prescribed for that. Now, section 140, it deals with kidnapping or abducting in order to murder or for ransom, etc. Earlier we had a separate section for kidnapping which was done with any of these objectives, and there was a separate section for abduction which was done for these objectives. So, this was earlier covered under section 364, 364A, 365 and 367 of the IPC. Now, it has all been covered under one single section, that is section 140 of the BNS. Similarly, section 96 of the BNS, now procuration of child has replaced section 366A of the Indian Penal Code, which dealt with procuration of minor girl. So, now it is not only procuration of a minor girl that is punishable, every child. So, we have replaced this gender specific term girl with the gender neutral term, that is child, under section 96 of the BNS. Section 141 of the Bharatiya Nyaya Sanhita deals with importation of girl or boy from foreign country. Earlier, it dealt only with importation of girl from foreign country. Now, we have also introduced the term boy here. The law says, whoever imports into India from any country outside India, any girl under the age of 21 years or any boy under the age of 18 years with intent that girl or boy may be, or knowing it to be likely that the girl or boy will be forced or seduced to illicit intercourse with another person, shall be punishable with imprisonment which may extend to 10 years and shall also be liable to fine. Now, the old provision relating to trafficking, which was section 370 of the Indian Penal Code, it has been replaced by section 143 in the BNS, and it says, whoever for the purposes of exploitation recruits, transports, harbours, transfers or receives a person or persons by using threats, using force or any other form of coercion, by abduction, by practicing fraud or deception, or by abuse of power, or by inducement, including the giving or receiving of payments or benefits in order to achieve the consent of any person having control over the person recruited, transported, harboured, transferred or received, commits the offence of trafficking. Now, in explanation 1 there is a change. See, rest of the definition is the same, but they have introduced beggary now. See, explanation 1 reads, the expression exploitation shall include any act of physical exploitation or any form of sexual exploitation, slavery or practices similar to slavery, servitude, beggary or forced removal of organs. So, the term beggary, it has been introduced by BNS. Then in explanation 2, the consent of the victim is immaterial in determining the offence of trafficking. Article 23(1) of the Indian Constitution, it prohibits forced labour and other forms of exploitation, and that is why trafficking cannot be permitted. Similarly, we have articles 39(e) and (f) of the directive principles of state policy that state that the state shall direct its policy towards securing that the citizens, men and women equally, have the right to adequate means of livelihood, and that the health and strength of workers, men and women, and the tender age of children are not abused, and citizens are not forced by economic necessity to enter avocations that are unsuited to their age or strength. That is why we need to prohibit begging. India does not have a central law on begging. What we have is the Bombay Prevention on Begging Act 1959, and that is the only law which serves as a model law on which almost 22 states and union territories have framed their own laws. So, what these laws do is they criminalize begging. Employing a person to beg or abetting begging, this is all a crime. They permit the local authorities to detain and rehabilitate those people who are found begging in public places. Then we also have related provisions under other laws, such as section 76 subsection 1 of the Juvenile Justice Care and Protection of Children Act 2015 says that whoever employs or uses any child for the purpose of begging or causes any child to beg shall be punishable with imprisonment for a term which may extend to 5 years and shall also be liable to fine of 1 lakh rupees, provided that if for the purpose of begging the person amputates or maims the child, then he shall be punishable with rigorous imprisonment which shall not be less than 7 years, but which may extend to 10 years and shall also be liable to fine of 5 lakh rupees. Then we have the Children's Act of 1960. Section 42, subsection 1 of this law says, whoever employs or uses any child for the purpose of begging or causes any child to beg shall be punishable with imprisonment for a term which may extend to 1 year or with fine or with both. In the year 2007, the case of Ram Lakhan versus State, In this case, the Delhi High Court had held that the Bombay Prevention of Begging Act is unconstitutional. Why? Because it violates the fundamental rights that are guaranteed under Articles 19(1)(a) and Article 21 of the Constitution of India. The court held that the mere act of begging cannot be said to be a crime. The court also observed that the court cannot order the detention of a beggar in a certified institution without giving him an opportunity to be heard. Further, in the year 2018, the Delhi High Court in the case of Harish Mandar versus Union of India, it struck down the Delhi Prevention of Begging Rules 1968 that had also been framed in accordance with the Bombay law to the extent that it was inapplicable to Delhi. The court said, artificial means to make beggars invisible will not suffice. Provisions that criminalize poverty, that grant unfettered powers to police authorities, now all these provisions they were held to be unconstitutional. Then in 2019, there was another judgment, Suhail Rashid Bhatt versus State of Jammu and Kashmir, in which the Jammu and Kashmir High Court also held that the Prevention of Beggary Act and the Prevention of Beggary Rules, these were unconstitutional. So, now moving on to the next provision, which is section 144 of the BNS, that replaces section 370A of the IPC dealing with exploitation of a trafficked person. It says, whoever knowingly or having reason to believe that a child has been trafficked. So, here again we have replaced the term person with the term child. In the title the term is person, but in the statute it talks about child. So, this is about protecting children of tender age who are below 18 years of age. So, the law says, whoever knowingly or having reason to believe that a child has been trafficked engages such child for sexual exploitation in any manner, then such a person shall be punished with rigorous imprisonment for a term which shall not be less than 5 years, but which may extend to 10 years. See the punishment, it has been increased here, and such a person shall also be liable to fine. Then under subsection 2, whoever knowingly or having reason to believe that a person has been trafficked engages such person for sexual exploitation in any manner, then such person shall be punished with rigorous imprisonment for a term which shall not be less than 3 years, but which may extend to 7 years and also fine. So, viewers, in this session, we tried to understand how the law relating to kidnapping has changed. Okay. What we have done? We have introduced the gender neutral term child. Earlier it was minor. See, minor in itself is also a gender neutral term, but the age of minority was differently pegged, like for girls it was 18, for boys it was 16. So, now what we have done? There is a uniformity in this. Further, sometimes the punishments have been increased. When trafficking is done for the purposes of begging, it has been criminalized, and rightly so. See, begging in itself, it should not be a crime, because why? Poverty, it should not be criminalized, as the Delhi High Court had also observed in a judgment. So, what these people require is that they need to be rescued and they need to be rehabilitated, and towards that end, these changes in the BNS, these are very, very progressive and futuristic. So, students, that will be all for this session. Thank you. Jai Hind.